To begin with, we are looking today at legal proposals to govern the manner in which communications are intercepted in India. There are three main issues this touches upon. One is the interception of telephone calls, the interception of posts, and the interception of electronic communications such as emails and so on. These meetings have by now a checkered history, so I should spend a few minutes just going over that. This is the 8th in a series of meetings that we have been having since 2013 on the issue of privacy. Last year in 2013, we had 7 meetings in partnership with FICCI, the Federation of Indian Chambers of Commerce and Industry, and DSCI, the Data Security Council of India. And this year, we CIS and COAI, the Cellular Operators Association of India, will also be co-chairing 5 to 6 meetings. This time only in Delhi, and we hope to have, we hope to do this, in focus groups, to not have general meetings in, in ISE in little basements like this that are forgotten, but to engage directly with, with public servants, with journalists, with academics in different groups. And hopefully that will be the format going forward. A brief introduction to the privacy bill itself. In 2011, the Department of Personnel and Training, that's the DOPT, which is a department to the Ministry of Personnel, brought out what they called a right to privacy bill. That right to privacy bill of the DOPT had 3 main sections. It dealt with the regulation of surveillance, which is the manner, and okay, I'll come to that. It dealt with the regulation of surveillance. It dealt with data protection, which is the manner in which data can be collected, processed, disclosed, and so on. And it also dealt with what it called unsolicited commercial communications, which is spam. In response, we proposed, CIS and a number of others, and we've been working in consultation with a number of groups in the industrial sector, with civil society, with judges and lawyers and other interest groups. We proposed a privacy bill. That bill, in response to the government's bill, in response to the fact that the government's bill had both data protection and surveillance together, we also proposed a bill with data protection and surveillance put together. But a decision now has been taken, to separate it, because the issues are quite different. In fact, very different. And clubbing them together may not make much sense. One is surveillance, for instance, implicates the criminal law completely, whereas data protection does not. The manner in which you regulate it must also therefore be different. The collection of personal data may be regulated by, by a regulator much like SEBI, perhaps. I'm not advocating this. But surveillance cannot be so regulated because it is a judicial function and it must obey the rules of criminal procedure in India. So what you see in front of you is a first draft skeletal framework. Does everyone have 2 documents in front of them? Okay, one is titled Provisions to Regulate Interceptions of Communications. The other is called Privacy Law in India. The other is a collection of 3 pieces which will provide a background to what we're talking about today. Now, if you have a look at the first document, which is called Provisions to Regulate Interception of Communications, it has a CIS logo on top. That's the document. This presents a first draft skeletal framework by which we hope to propose that communications privacy is regulated and protected. What does that mean? It means providing a framework in which lawful interceptions of telecommunications, of posts, and of electronic communications such as emails, as well as messages such as blog posts or forum posts, can be intercepted or monitored. Now, before we go further, I should point out that I don't want to go into too much legal history over here, but a little bit may be required. Interceptions of communications have a long history in India. Unfortunately, as I hope I will be able to point out going forward, this history has not really worked out well for us. In 1885, the colonial government enacted the Indian Telegraph Act. Section 5, subsection 2 of the Indian Telegraph Act provides an empowerment to the central government, at that time the Governor General in Council, to intercept phone calls, at that time telegraphs, to intercept telegraphs, now all telecommunication activities. Rule 419A of the Indian Telegraph Rules 1951 provides the procedure. Now, between 1885 and 1996, there was not much judicial attention given to the manner in which telephone calls were intercepted in India. This is ironic because whereas the law in the United Kingdom, in the UK, from whence we borrowed our law, whereas their law underwent a series of changes almost every 10 years, ours remained unchanged. We retained a colonial framework which was briefly amended in 1961. Now, in 1996, in the Supreme Court judgment of People's Union of Civil Liberties, PUCL versus Union of India, Justice Kuldeep Singh delivered a judgment that required that any law that allowed for interceptions of phone calls must follow a procedure that is just, fair, and reasonable. Those of you who are lawyers might be familiar with this term. This is the procedure set down. This is a requirement set down in the case of Maneka Gandhi. This provides a very broad introduction to the way in which telephones may be intercepted. Now, in 1898, and you will see there's about 20 years difference. The Telegraph Act is 1885. The Indian Post Office Act was 1898. In 1898, the Indian Post Office Act, by Section 26, provided for the interception of postal articles. Now, why is this important? Because not a lot of interception takes place of posts. It's because the interception power, which is given in Section 26, is almost exactly the same as interception power contained in Section 5(2) of the Telegraph Act. So one can measure the two with the same yardstick, so to say. Now, this is interesting because in 1898, there were very few Indians in elected legislative bodies. When the Indian Post Office Act went to a joint, what was then, what they call the equivalent of a select committee, it went to a standing committee in the Legislative Assembly, if I believe. There were the only two Indian members on that committee both objected to it, saying that it was an attempt by a colonial government to intervene in the free speech rights of Indians. Now, after independence, we made no changes to this. We continue to retain a colonial law that the only legislative attention it has received has been by nationalist Indians in 1898 who rejected it, who criticized it and rejected it. Yet we maintain it. And this language is also present in the Telegraph Act. The Law Commission, in its 38th report, when it looked at the Post Office Act, specifically mentioned this. It talked about the fact that both Section 5(2) and Section 26 of the Telegraph Act and Post Office Act may be unconstitutional. Why did it say unconstitutional? Because Section 5(2) and Section 26 both say that an interception can take place on the occurrence of a public emergency or in the interest of public safety. These are very broad terms, public emergency and public safety. But these, on the face of it, appear to conflict with our Constitution. The legitimate grounds for abridging free speech in India is contained in Article 19(2) of our Constitution. Article 19(2) has 19(1)(a) and 19(2) have seen a number of has received a lot of judicial attention. There is no ambiguity on this process. There can be no abridging of free speech that does not fit within the grounds that are mentioned in Article 19(2). And Article 19(2) does not say that public safety or public emergency can be a ground to take away free speech. It does say public order, which was introduced by amendment in 1951, but not public emergency or public safety. It is for this reason that the 38th Law Commission, which is an independent Indian legal body, noted that Section 26 and Section 5(2) may be unconstitutional, and it called for an overhaul. That overhaul has not taken place yet. Now, in 2000, going forward a little bit more on this history, in 2000, Parliament enacted the Information Technology Act, the IT Act. The IT Act, when it was first enacted, did not properly deal with the manner in which emails and other electronic communications could be intercepted. By amendment in 2007, new sections were put in. Now, Section 69 and 69B of the IT Act together set forth a framework to enable the state to intercept electronic communications. Now, both these provisions, 69 and 69B, they omit the controversial language. They omit the use of the words public emergency and public safety. but they retain exactly almost the other language that was that is contained in these colonial laws, the Telegraph Act and the Post Office Act. This is where we stand today. Rules were issued in 2009 under the IT Act to enable the state to intercept electronic communications, to monitor, to decrypt. Provisions exist in the IT Act to force a person who encrypts his or her communication to give up the encryption code, the encryption key. So this is our current interception framework. It is contained in 3 laws. 2 of those laws may be unconstitutional, and this is not an opinion given by me personally. This is an opinion given in 1968, as far back, as early as then, by the Law Commission of India. There has been a lot of confusion regarding India's interception provisions and privacy law. There are currently 2 matters in the Supreme Court as we speak, which deal with privacy. One matter has been brought by Ratan Tata against the Union of India, but there have been a lot of impleaders. There have been a lot of people who have joined party to this suit. The other matter deals with the unique identity scheme, the Aadhaar card scheme. Now, the technical issues are a little different, but the broad substantive issue of privacy is the same. At heart, at the root of this matter, is a very simple point. Privacy of Indian citizens cannot be taken away except by a law of parliament. This law of parliament must, because we must obey Maneka Gandhi, which is a 9-judge bench, if I'm not mistaken. This law of parliament, 7-judge bench, I'm sorry. This law of parliament must provide a procedure that is just, fair, and reasonable. To obey this mandate, a law must be proposed which provides a procedure that is just, fair, and reasonable to aid business efficiency. It should be uniform across, we believe, it should be uniform across telephones, posts, and emails, to allow for communications to be intercepted. This is a very broad and very brief, this might be long, but it's actually a very brief legal introduction. The specific legal issues are a bit more complex, and we'll go through them individually section by section. So I've briefly introduced the law and the area. Let me also briefly give a sort of a political economic background to what we're doing. Why is the government suddenly looking at privacy? Surprisingly, it did not arise because there is a genuine need for privacy law, and it did not arise because in 1968 the Law Commission recommended a new law. It arose because in 2010 India failed what is called a data adequacy assessment audit. What does this mean? India and the European Union are currently negotiating a free trade agreement, an FTA. And the essential pillar of that free trade agreement is the ability of European personal data to flow into India so that it will enable the Indian outsourcing industry. This is a significant chunk of India's GDP. Now, in order for European data to flow to India, there are 3 ways in which European data can flow to any country in the world. One is if that country has a legal system and legal infrastructure, that is statutory infrastructure, laws that are capable of protecting the privacy of that information. The second way is if, in the absence of laws, individual data transfers are governed by contracts. Now, this is the manner in which it currently works with India. So, if, say, a European company or any company handling European data wants to send that personal data to, say, a company, like, say, a large Indian IT company like Infosys, for example, it will be governed by a contract, and that contract has to be substantially similar to what is called a standard contractual clause that is given in by EU law. So, that's the second way. And the third way is what's called the safe harbor principle. This is the arrangement that Europe has with the US, with America. Now, unofficially, I understand that India has been pushing for a safe harbor principle, but this was rejected. Therefore, India then asked for a data adequacy assessment. The EU then commissioned a gentleman called Graham Greenleaf to conduct the assessment. India failed the assessment. That means that Indian law did not meet an international best practice that is capable of securing the privacy of European data, and this would result in a significant loss to Indian industry. Therefore, privacy law was first looked at by the DOPT. However, this is not the first privacy law in India itself that is being proposed. The first privacy law that I've managed to encounter was actually 1980 by it was raised by a member of parliament called V.N. Gadgil, or maybe it was P.V. Gadgil. There were two Gadgils in parliament. It's one of the two, and he proposed the law because in 1980, so after the emergency was rescinded, after the proclamation was lifted in 1977, and the press was suddenly free. In the 3 years between 77 and 80, when Maneka Gandhi was re-elected, she received a lot of criticism, and the Congress party also received a lot of criticism. So when the 1980 general election took place and Indira Gandhi came back to power, Mr. Gadgil, who was a Congress MP, proposed a law which would, under the guise of protecting the privacy of public figures, such as rulers or celebrities, you could infer, proposed that the ability of the media to report of certain aspects of public individuals be curtailed. And this was disguised as a privacy law. It was called the Right to Privacy Bill. It was fortunately defeated. The Gadgil's privacy bill was almost exactly, in fact, it was lifted almost verbatim from the few bits that I found. The thing is that, the Lok Sabha and the Rajya Sabha's electronic records only start from 1996, and before that they're a little bit sketchy. So official records are very difficult to come by. Now, I've got an unofficial version of Mr. Gadgil's bill, but I want the version on the Lok Sabha letterhead so that I can quote it. If the unofficial version that I've received is true, Mr. Gadgil's bill is almost exactly the same as a similar proposal introduced in the House of Lords in 1960 in England by Lord Mancroft, who had very similar motivations. This was the time when the British tabloid industry was mushrooming, and the law lords and the lords who represent the British aristocracy were little, quite, let's say, alarmed or taken aback by the way in which reporting was going, and they proposed a privacy bill. Now, this is how privacy has generally developed in India. It has developed as a response to media, to the way in which news is reported. The first press commission made note of the fact that the privacy of individuals has to be respected. The second press commission in 1982 also talked about it, devoted an entire chapter to privacy. It had a questionnaire. Privacy was also looked at by the committee to review the working of the Constitution, which was the Jeevan Reddy Committee, which was appointed under the first NDA government. That committee recommended that there be a new article inserted in the Constitution. It recommended that there be an Article 21B, I think, to guarantee to all Indian citizens a right to privacy. So this is the specific, political, legal background from whence we emerge, and this must inform our discussion. This is not something out of the blue. It is not a bolt from the blue. We are looking at it now, and all of us are in the media, in public, in civil society, in government. We are, of course, prompted by the fact that we live in a world of mass surveillance. This is a reality. Revelations like that made by Edward Snowden, of course, give this matter some urgency. But this is not new. This is being looked at by our government, by our MPs for a long time. The Law Commission looked at this in 1968, the Press Commission in 1982, the Jeevan Reddy Commission in 2003, the Supreme Court in 2 cases thereafter. So we are just inheritors of this, of this process.